Good afternoon, everyone. My name is David Lepofsky. I am moderating this afternoon's Law Society webinar entitled Enhancing Access to the Courts, the Final Chapter. Let me take a minute to tell you a bit about who I am. I've been practicing law in Ontario since 1981. For the first 33 years after that, I was counsel with the Ministry of the Attorney General for the province of Ontario, arguing civil and constitutional cases and later arguing criminal appeals. I retired from that position at the end of last year. I'm now part-time involved as a visiting professor at the Osgoode Hall Law School here in Toronto. And the rest of my time is being spent doing volunteer advocacy for the rights of people with disabilities. I wear three hats. I'm the chair of the Accessibility for Ontarians with Disabilities Act. We advocate for accessibility at the provincial level. I'm the co-chair of Barrier Free Canada. We advocate to get the federal government to keep its promise to pass a Canadians with Disabilities Act. And finally, I'm chair of the Special Education Advisory Committee of the Toronto District School Board. In my capacity today, I'm here to assist you watching this program to get some practical action tips on how to ensure that you are able to effectively accommodate the needs of clients, witnesses, and others with disabilities involved in the court process. This is the fifth of what isn't meant to be a five-part series. It is not necessary for you to have watched the first four to benefit from today. You can watch them all in any order you wish. We do encourage you to watch them all. What is the problem we are addressing? Well, I'm going to try to put it a little differently than I have before in case you've watched any or all of the previous episodes of this series. Is that a plug? Yes, it is. Think of it this way. Our world around us, our entire world around us, was built or designed on a really odd and unwise basis. It was built on the assumption that it was meant for people without disabilities. So our transit systems, our schools, our workplaces, and indeed our courts historically were designed and operated, not just the buildings, but their entire design was premised on this unexpressed but bedrock principle that they are for people without disabilities. It's an unwise way to approach the world because, of course, our world is full of people with disabilities. Right now, in Ontario, we're talking about 1.8 million people. Across Canada, over 4 million. Around the world, estimated to be as many as 1 billion. But those numbers understate the situation because everybody eventually gets a disability if you live long enough. I've often said that we are the minority of everyone. The old way of operating the world, of designing public transit or products or workplaces, indeed courts, was to design them for people without disabilities, and then when people with disabilities came along, they couldn't quite fit in or couldn't fully take part because of barriers they encountered. The solution was to try to find fixes or accommodations. That's the old way of doing things. The new way of doing things that is catching on around the world is called universal design. Build accessibility in so that the buildings we work in or attend, the programs we want to benefit from, the jobs where we may want to work, are ones in which all people of all abilities or disabilities can fully take part. We're working towards that. It's ultimately a requirement of the Charter of Rights, which guarantees equality to people with disabilities, human rights codes that do the same, and the requirement in the Accessibility for Ontarians with Disabilities Act that Ontario become fully accessible by the year 2025, less than 9 years from now. But in the meantime, as we try to go from that old world based on that unwise, some might call it remarkably foolish premise that the world was only designed for people without disabilities, to a new world based on universal design, we still need to work out accommodations. We still need to enable people with disabilities to fully participate. Courts are no exception. They are as much a victim of this tradition, this unfortunate tradition, as any other public or private institution in our society. The difference is that there's no one in charge. There's no one president of the courts who can make sure all the barriers are removed. Responsibility is defrayed. Some is in the hands of judges, some is in the hands of court administrators or governments that operate the court facilities, and to some extent, some is in the hands of you as lawyers or paralegals who are going to court. What we're trying to do here today is to provide you some more of the tools, as we have in the first 4 episodes in this series, to enable you to be able to discharge your responsibility. What are your responsibilities as a lawyer or a paralegal working with people with disabilities in the court process, whether as clients, as witnesses, counsel, opposing counsel, or others? Well, they really boil down to these. First, you have a fundamental responsibility to figure out as quickly as possible if anybody you're working with, your witnesses, your clients, or others, if they have a disability that requires some kind of accommodation, if they're going to encounter barriers in taking part in the court process. Second, you have a responsibility to bring it to the attention of the courts as soon as possible. The earlier you notify the court system, the more likely they're going to be able to accommodate it or fix it. That has been a theme in this series that has come up over and over again. But we're going to repeat it again today because it takes on more importance each time we address it. The next obligation you have as a lawyer or a paralegal presenting a case in a court or a tribunal is to make sure that the way you conduct your case itself doesn't create barriers for witnesses or clients. And finally, your judge or your jury or your tribunal may have misunderstandings about disability that could get in the way of a fair and accurate outcome. So you have a responsibility to figure out what stereotypes they may entertain and figure out ways to educate them so that they operate based on an accurate understanding of disability, not an inaccurate one. That's what we're covering. So if we were going to do one of those TV things where they say previously on, we'd run a bunch of video clips. The Law Society doesn't have that kind of whiz-bang technology, so unfortunately you're stuck with me. In our first episode, we gave you an overview of this issue at large. We had you hear from 3 judges talking about a judicial perspective and 2 people from the Ministry of the Attorney General talking about how our courts, in our Ontario-run courts, not the federal or municipal ones, but the Ontario-run courts, have a court accessibility coordinator at every major court facility to assist you in arranging accommodations once you notify them. We have since then also, in the ensuing episodes, had panels on different recurring disabilities, dealing with vision loss, people with hearing loss, people with learning disabilities, people with intellectual disabilities, people with communication disabilities, people with mental health issues, people with mobility disabilities. So if you look up the earlier programs, if you haven't seen them, check out the ones that might touch upon areas that you're interested in and follow them. We encourage you to do so. Let me, before we turn to our first panel today, let me just give you a couple of pieces of preliminary information you need to know. Number one, good news, this program is accredited for 2 hours CPD credits, and they count as professional hours. I'm also told that for Law Pro purposes, if you need this, that you can get credit towards risk management and insurance rate reductions. Being a former public sector lawyer, I never thought about that stuff, but if you get credit for it, that's great. Third, you were invited to email in questions to us. You can keep doing so. There is some kind of box up there on the screen that somehow you click on and type something and a question will come through to us. At the end of our program today, we will be looking at those and trying to address them with our panel. And finally, if you want more information about all of this, the good news is that Ontario has a plan to make all of its courts disability accessible. It's a report of a joint committee of the bench, the bar, and the judiciary that was made public about 9.5 years ago. It's called the Weiler Committee Report. It was prepared by a committee chaired by Court of Appeal Justice Karen Weiler. It's available in the materials for today's program and on the Court of Appeal website. I encourage you to take a look at it. There's also a permanent committee of the bench bar in the government, the Ontario Courts Accessibility Committee. We're trying to oversee the implementation of that report. If, as a result of this program or anything else that happens, you want to raise any concerns or identify any barriers for us, contact us either through the Ministry of the Attorney General or email me directly at david.lepovsky@gmail.com, and I'll overcome my natural shyness and make sure your concerns are raised. Finally, if you want to learn more about accessibility generally, and if you happen to be on Twitter, my Twitter handle is @DavidLepovsky, DavidLepovsky. I tweet extensively, not only about accessibility in courts, but about accessibility issues here and abroad on a wide range of topics. So with that, here's how today is going to unfold. First, we've selected 3 disabilities that were not covered in prior programs and that we think that's important for you to learn about, and we're going to turn to that in just a moment. Next, we will have a discussion with 2 representatives from the Ministry of the Attorney General's Accessibility Unit, 2 fabulous people who've been working on supporting our court access coordinators and helping the ministry plan to make its court system fully accessible. They're going to talk about what we've learned since we started these webinars about what's going on at the front lines and give you some examples of some of the more complicated cases that they've had to deal with. Finally, we will have a panel of 2 of our 2 judges who are both members of the Courts Accessibility Committee and 1 tribunal chair who will be talking to you again about the perspective on these issues from the person who is running the hearing, whether court or tribunal hearing, and how you can help them help you. So with that, let me stop my introductory ramble and turn to our first panel. I'm turning to my left, and we have 3 wonderful presenters here who I'm going to speak with to talk to you about 3 different disabilities. To my immediate left is Angela Covert, who's going to be talking to us about multiple sclerosis-related issues. Beside her is Stephanie Moser, who's going to be talking to us about autism spectrum disorder and how people with that condition can be accommodated in the courtroom. And finally, at the end of the panel, to my furthest to my left, is Gail Simpson, who is going to be talking to us about people with traumatic brain injury and how their needs can be accommodated in the courtroom. So let me start with Angela, and I'm going to start with a fairly rudimentary question, which is, who are you, and what do you do, and what do you work, where do you work, and how do you know about this?
Well, thank you very much, David. I'm excited to be here. So my name is Angela Covert. I'm with the Multiple Sclerosis Society of Canada. I work in the Ontario and Nunavut Division. My role is Manager of Education, so providing opportunities across the province for education for those diagnosed with MS and affected by MS.
And that organization's a nonprofit.
Correct, it's a nonprofit.
So let's talk about multiple sclerosis. First things first, what is multiple sclerosis?
Well, MS is the most common neurological disease affecting young Canadians. Basically what happens, the fatty substance, which is the myelin that protects our nerves, becomes damaged, and so nerve transmission becomes disrupted so that the brain is unable to give the message to whatever part of the body needs to do its job. And scarring occurs, which is the sclerosis part on that myelin, causing this disruption. So basically, multiple sclerosis is just that, a disease of many scars.
And how does it manifest itself in a person?
Most individuals will discover that they probably have something neurological happening when they start to have things like blurry vision, double vision, tinglingness, numbness, maybe some mobility concerns, drop foot, dragged foot, etc., which would first lead them to their GP to determine what might be happening in their body.
And tell me about numbers. How many people in Ontario or in Canada have MS, and what's the kind of age profile for onset?
Most people will be diagnosed between the ages of 15 and 40, not suggesting that they could not be diagnosed prior to or after that age range, but most between that age range. We estimate 100,000 individuals living with MS in Canada, and we've broken it down to roughly 29,000 in Ontario.
And give me the kind of different ways it can affect someone and the kind of spectrum of severity that we can see in a person.
Well, Okay, so most individuals are diagnosed with relapsing remitting MS, coming and going. So in a mild form of the disease, they may only have 1 to 3 attacks during a year, so relapses that occur and then go into remission. But then on the worst case scenario or further down the progressive state, could be an individual who has no ability for any type of mobility and are primarily in bed or in a chair on a regular basis.
So a person could have it one day and not have anything manifest the next day.
Definitely.
Is it predictable?
No, not a predictable disease at all. So an individual could be diagnosed today and have a very full life without very little disability for the rest of their life. Another individual might see progression within 5 years. So at time of diagnosis, most neurologists cannot even suggest what the individual will experience.
And is it predictable day to day? Can you have good days and then bad days, and you don't know it's going to be a bad day tomorrow?
You could have good days and bad days, definitely, and you don't necessarily know what tomorrow might look like. You can plan for if there's need for a very busy day the next day to maybe rest up the day before to prepare for that day, but generally it's hard to suggest based on many factors.
All right. Do people with MS typically know they have MS?
Yes, they would know that they have MS once diagnosed. So once they've had symptoms that for them are worrisome, again, the numbness, tinglingness, blurry vision, double vision, chances are it's at a point where they want to pursue to find out what their issue is. At that point, the GP might just take a wait-and-see attitude. As things may be worse or another relapse occurs, so another incident of such symptoms, then they'd be referred to a neurologist. So I would say yes, generally people know it's not.
But are there people out there who have it and don't know, but it's manifesting?
Very benign form of the disease, possibly, so they may not know at this stage.
And do people with MS typically, for our folks watching this today, lawyer or paralegal, if somebody comes into your office, a witness or a client, if they have it, are they likely to say they have it, or how do they self-describe?
I would suggest that the majority of people with multiple sclerosis, if they feel that their symptoms could affect the next steps within a court case or meeting with a lawyer, they would definitely inform the lawyer of their diagnosis. Now, they may not be as self-aware to specifically say, though, this could affect me this way. So it would be of benefit for the lawyer to tease out some of the information.
All right. In terms of red flags, in case I'm a lawyer and or a paralegal, I'm interviewing a client or a witness, what should I be looking for in order to possibly see whether I should ask if they haven't mentioned it?
Well, I would think you would pretty soon notice if there are any kind of cognitive lapses, such as maybe some memory loss, or being asked by the individual to repeat the question. If there's been some, you might notice very quickly that the information processing is a little bit slower than maybe somebody else you've spoken to. They may also even say to you one day, I can't come in and see you because I'm just really, really, really tired. And so that fatigue factor is there. And so they might be more apt to call in unable to meet with you. So you might notice if you've had 2 or 3 appointments with them that there's been some changes like that from appointment to appointment that you've noted.
And I'm a lawyer or a paralegal. I've got those red flags. How do I ask? Do I say, hi, do you have MS? Or what's the way to politely or respectfully ask?
I think my suggestion would be is not specific to the disability, but ask, is there maybe a chronic illness or some something that you've been diagnosed with that might require some accommodation during this process.
Okay. And folks, this is a theme that comes up in a number of our programs that label or no label, sometimes you just, by focusing on telling witnesses or clients, here's what the court proceedings is going to involve. Do you have any accommodation needs that will enable you to fully participate? They'll come out, hopefully. Now, talk to us now about the meat and potatoes of our discussion today. With this information all in hand, what kind of accommodations might a person with MS need if they're going to be testifying in court, or if they're going to be a client whose case is being heard in court?
I want to address some of the specific symptoms of MS and what accommodations for those symptoms, but I want to have an overarching idea placed here, because it's very, very key, is issues like the fatigue aspect and the heat concerns of individuals with MS. And I want to stress that the symptoms I'm about to describe are very common, but can be much more pronounced if the individual's core temperature is overheated, either through a hot sunny day, the room of which they're in, be it in an interview room or in the courtroom, if the air conditioning is broken down. So how heat can greatly affect.
Wearing a suit and tie.
Wearing a suit and tie, yes, definitely. Maybe having traveled to the courthouse, let's say from, in Toronto we use Wheel-Trans or other paratransport. And if their car, for whatever reason, broke down and so they had to use the general system, then they're going to get their bodies overheated. So heat is a major factor.
And what does that do? What does that trigger?
Worsens all this either worsens the current symptoms that they're experiencing, which I'll describe, or can bring on a temporary relapse during that particular time frame.
So the symptoms that could worsen
So visual problems are generally maybe painful eye movements, blurring, double vision, blindness possibly in one or both eyes.
And that's temporary, though.
It can be permanent with the blurry vision, double vision, or visual problems. Definitely if they don't experience that generally, but heat is introduced into the equation, then those symptoms can be pronounced. But if it's a general symptom that somebody is experiencing, then of course it's generally permanent, so you're looking at an alternative format of material such as audio or large print.
And we've had a whole panel on how to accommodate people with vision loss in the court process, so we can.
And most people with MS would be able to stress this is just a one-off symptom I'm experiencing right now or not.
That's one symptom. Let's do the others.
Cognitive impairment. About 50% of individuals with MS will have notable cognitive impairments such as memory, recall problems, abstract reasoning, problem solving, hand-eye coordination possibly, verbal fluency, or speed of information processing. Again, it's important if you're meeting with the individual to have it free of distractions, speaking slowly, giving instruction very clearly and broken down steps, etc.
Okay, so let me just focus in. I think our people watching our presentation today are thinking, well, my witness's memory of what happened at a particular time is going to be important. Are we talking about losing memory altogether, or it's just during the relapse? If we kept the air conditioning up and they weren't overheating, would the memory be there?
Yeah, most of the memory loss tends to be momentarily, so 5-10 minutes ago, let's say, so short term. I would suggest that most people would be able to recall information or a situation that they experienced, but they may need to, again, back to how you ask them the questions, take that time and break it down into smaller bits rather than just saying, tell me what happened on this particular day.
Okay.
So breaking it down.
Okay, other accommodation needs or other symptoms we need to know about.
Okay, so I spoke about the heat intolerance, and so of course that would just be very simple, just looking at how they travel to appointments, ensuring meeting space is cool, providing them with water if that would be something to help cool their system. But bladder and bowel problems with MS, about 80% of people will have some type of bladder issue or a bowel issue, and that's where they just need to get to the washroom when they need to get to the washroom. So being very clear with them where washrooms are within the facility they're going to, if possible, to make the washroom close, choosing the courtroom closest to the washroom, and the accessibility issues, of course, around washrooms, should that be a necessity. And ensuring that for some people with severe bowel or bladder problems will have had some kind of routine that they have set up on a day-to-day basis, so watching when the meetings are set so that they can accommodate those routines. So
one of the things, and this has occurred with a number of disabilities, if the person has increased need to go to the washroom or needs to be able to go when the urge hits without a lot of turnaround time, that's the kind of thing that counsel or paralegal should be learning about from their witness or client and talk to the court about, so it's understood between everyone that is expressed courteously, but of course, but that if the person has the need, they may have to just say, excuse me, Your Honor, I have to go, and then they go without the usual formality of waiting for counsel to raise something.
And I wanted to stress, David, that along the lines of routine, if an individual is more progressed with the disease process, chances are they are relying on some type of personal care in the home, so an attendant or a personal support worker. And there's very strict times around when those individuals come into their home to provide them with care. So again, there would need to be flexibility around that. So I know, for example, that if I ask a client to come to my office and that's where we're going to have our meeting, and I ask them to come for 10, they might say, no, you know what, my attendant comes at 8:30 and I'm not finished my routine till almost 10. It will have to be later in the day or mid-afternoon.
So let's focus now on accommodations in terms of court scheduling. Our courts work on a usual schedule of when we start, when we break, when we finish, and how long your case will be heard. What kind of accommodations might a person with MS need in terms of court scheduling?
Well, one would be to ask if they are indeed more progressed, when they have care coming into the home, and how we can adapt around the time frame that way, be it the beginning of the day or end of the day. But most importantly are things like I mentioned, the heat and the fatigue. So again, if there's court in the summer, you may not want to have the session in the afternoon because they would have maybe come to the courthouse in a warmer part of the day. And so you may want to have an earlier morning appointment.
Is it possible they might also not be able to have full court days for their case?
It's very possible around the fatigue factor. So that's the second part, is fatigue is not like what you or I might, and I don't know your fatigue level, but what we might experience at the end of the day at 5 or 6 o'clock. Fatigue often with an individual with MS can be so severe that at 10 o'clock after a decent night's sleep the night before, 10 a.m., they just want to lay down and go under the couch and have a rest. So fatigue is very unique to each individual. Majority of people with MS will say they have fatigue issues, and they know when they're better during the day, and so working around that. I mentioned a little while ago, though, that if they know that they're going to have a busy day tomorrow, they may have taken some time today to rest and to prepare themselves, build up that energy bank of reserve. So if you knew that on this day they will have to be in court from whatever, 9 to 5, and there's going to be certain breaks during the day where they may be able to also be accommodated by having a place to lay down for half an hour, which would be fabulous, they will then the day before take that time to rest and prepare.
And something counsel can also, and paralegals can also think about is that if your client or witness is going to have quite a journey to the court, it may be worth trying to reduce the consumption of energy that they've got to make in the morning by seeing if they can stay somewhere right near the court the night before. Obviously, these all have cost implications, but the more you can reduce that pressure, and the more, if it's summertime, you reduce the exposure to heat before you get to court, you're basically saving up your resources.
And I think financially, you may also want to consider over using a paratransport system, using a taxi for that particular day. Because
paratransit can take longer, and you got to wait for a half an hour in case they're not on time and so on. So there's more time commitment to just get somewhere.
Correct.
All right, any other in-court accommodations you're thinking of? Let's talk just briefly about, you talked about structuring questions.
I think you need to ensure that, again, you're not asking a long-winded question to expect a long-winded answer, is to break down your questions into clear segments and getting them to answer one by one rather than making sure that you want to ensure that they process the information. My assumption, and not being a lawyer myself, is that you're preparing the individual prior to give them a sense of what they might be asked, either by yourself or the opposing.
Okay, let me turn now to just a couple of other things quickly. Can you tell me, a witness, you're bringing a witness or a client before the court who's got MS, and you're going to be before a judge or a jury or a tribunal. What stereotypes or misunderstandings out there might they entertain, or do the public generally entertain about MS?
Well, a lot of individuals with multiple sclerosis do not look sick. They look well. So you can't physically see the symptoms, the invisible symptoms, like the cognition, fatigue factor, or visual. And so often they are just about, there's nothing wrong with you. What do we need to accommodate? You look pretty good. In a family circumstance, that is usually taken as, well, you're pretty lazy if you can't do what we're asking you to do or participate in because you look pretty good. So the misconception that they're not ill. The other concern would be the cognitive issues, is that because it does take some individuals a little bit more time to process information and then respond, that they might be not intelligent.
So in other words, the stereotype could be that the person because of the time they take to process and respond, maybe there's an intellectual disability where, in fact, they're actually quite a bright person. It's just a processing time. And needless to say, there are people with MS on an entire spectrum, so some show none of these symptoms or almost none of these symptoms at all. Mm-hmm. It's all quite individual. You can't just assume that because someone has MS that this checklist is present. If you want to educate a judge or a jury or a tribunal member hearing a case about MS to assist them in accurately assessing their evidence, who would you call as an expert witness? Who knows MS?
You would want to call specifically a multiple sclerosis specialist, a neurologist, and preferably somebody from an MS clinic, of which there are right across Ontario and Canada. Right,
okay. And you mentioned this earlier, but just so we know, who diagnoses MS?
Neurologist.
Neurologist. All right, anything I've left out before we move on to our next panelist?
I do not believe so. I look forward to any questions.
All right,
you.
I'm going to have you just pull back a bit so I can have a notional line of sight, not that I have any. And I want to now turn to Stephanie Moser. So I'm going to ask you pretty much the same question, starting with who are you? What do you do?
Well, my name is Stephanie Moser, and I am a social worker. I have a master's degree in social work. I've moved to Peterborough a couple years ago, but prior to doing that, I worked at an organization called the Geneva Centre for Autism for 12 years, and I've done some work with Autism Ontario, and presently I'm in private practice in Peterborough, primarily supporting teens and adults with autism spectrum disorders and their families.
Okay, so we've all heard autism mentioned. It's all over the media from time to time, but some people may not know exactly what it is. What is it?
It's a spectrum disorder, for number one. So there's a huge range of difference in individuals with autism. It's a neurodevelopmental disorder, so it's a brain disorder. And typically, children who are more affected by autism would be picked up around 18 months of age. But in my experience, working with some of the older folks, some people who have average to above average intelligence may actually not be diagnosed now until they're adults. But what primarily is, it impacts the way somebody interacts with the world through their social skills, their communication, and their behavior. So having restricted behaviors, repetitive patterns of behaviors and interests, and so can impact their ability to interact with other people. And another pretty significant factor is the way somebody perceives their sensory environment. So the way that they take in sights, sounds, smells, all those sorts of things can be really they can be really impacted by those sorts of things.
Okay, we're going to get back to that some more shortly. Mm-hmm. So it's a spectrum disorder.
It is.
People are all, it's not all or nothing.
No, so there are a number of individuals with autism who may not be able to communicate verbally at all. That's not to say they cannot communicate, but verbally they may have very limited ability to do that. And then there's some individuals who have quite advanced verbal skills, been talking from the age of 2 with a huge vocabulary. That does not necessarily mean that the communication matches understanding. So there are some individuals with autism who use advanced language, some of it that's scripted, some of it they know large vocabulary, but that does not mean that their comprehension necessarily matches that.
So, and you're born with autism?
You are born with autism, but typically it does not get picked up, as I said, till at least 18 months is when those signs for the children with more significant cognitive impairments.
Right.
Cognition is another issue. I work with university students who have exceptionally high IQ, some of them, and I also work with individuals who have intellectual disabilities as well. So there's a huge range of difference in terms of cognitive functioning.
So autism doesn't tell us anything about their level of intellectual ability?
Not at all, no. And I think there's a misconception as well that communication, there are definitely some people who cannot communicate verbally and may use technology to communicate. And I think in the past, there was an assumption that those individuals had lower IQ, and we are now learning that that's not necessarily the case. That some people who cannot communicate verbally are able to have quite advanced intellect as well.
Talk to me about numbers. How many people are on the spectrum?
So in the United States, the Center for Disease Control, they use the stat 1 in 64. Here in Ontario, Autism Ontario uses the stat 1 in 94. So it's approximately 100,000 people in Ontario who meet the criteria for an autism spectrum disorder. So what was once thought to be a rare disorder is now seen to be not nearly as rare as they had thought.
Okay, people who are on the spectrum, to what extent should a lawyer or paralegal who meets someone who ends up happening to be on the spectrum, to what extent do they know they are diagnosed versus undiagnosed?
I think the diagnosing of individuals, even individuals with something that would be formally known as Asperger's syndrome, what people maybe should know.
Which is one form, it's not the only form.
Well, and interestingly, actually, Asperger's syndrome is not a diagnostic criteria anymore. Since the DSM-5 came out,
Right.
It's now autism spectrum disorder, and they took Asperger's syndrome out of
Right,
that.
right.
But those individuals, if they were diagnosed, they would have a lot of insight. Many of the individuals I work with have a lot of insight around their disability. Many individuals I work with feel quite proud that they feel autism is a way that they interact with the world, and it's a primary way they interact with the world. And then there's some individuals who maybe with more cognitive difficulties may not have the insight or understanding. And then there are individuals that I am seeing who are getting diagnosed as adults. So they may have known that they were in some way different, unique in school, intelligent, but never quite fit. Those people I'm actually seeing after their children get diagnosed. They read and they understand that, oh, this all sort of makes sense for me. And sometimes psychiatrists in the mental health system, somebody may have a mental health break or a mental health issue, and things aren't adding up when they go to the hospital or psychiatrist, and that's when people are cluing in that, hold on, there could be something other than a mental health issue going on, and they're getting picked up
So
there.
unlike what we've just heard from Angela about MS, if somebody has MS, particularly if it's present, like it's not in remission, she gave us the understanding that they likely know they have it. If somebody is in my office as a witness or a client, if they're on the autism spectrum, should I be assuming they would know and they would tell me, or they might not know, or they might not tell me?
All of the above, I think. There are some people who also are concerned that people have preconceived notions of what it means to have autism, and therefore they may not want to may not want to divulge that information. So I think it would be beneficial, as Angela noted, to ask if you have been diagnosed with anything, and really to stress why it's important as a lawyer that you know that you're looking to accommodate, to support, so that they feel supported in bringing that out. But
so if you put the question as something like, do you have any here's what you need to do in court, here's what we're going to do.
Yeah.
If you have any diagnoses or any conditions that we need to accommodate, let us know.
Yeah, and I also often ask, when I'm trying to figure things out and somebody may not necessarily be diagnosed, I'll ask, when you were in high school, did you have an individual education plan? Did you have, if you're in university, did you have accommodations? Those sorts of things, to have a sense of.
And just so folks know who are watching, if you're not into special education, individual education plan is what schools are required to provide to kids with special needs if they need their needs accommodated in school. So it's kind of a term of art. It's with a capital I, a capital E, and a capital P.
Yeah, so sometimes that's helpful as a way to broach that topic.
Okay, and what are the red flags that counsel or paralegals should be looking for? They're interviewing a client or a witness that should make them at least wonder whether this could be an issue.
So people with autism spectrum disorders typically have a difficult time reading body language and facial expressions. So
do we blind people, by the way.
So if they're not picking up on sort of some of the subtle signs that you're trying to end a meeting, for example, some of the times that I'm trying to end a meeting with a client, I may pick up my papers and sort of turn my body, and that's sort of the polite way of ending a meeting. Though people with autism some of them, if they had not learned those skills in a concrete way, would not pick up on that's ending a meeting. They themselves may have a limited range of facial expressions, or their facial expressions may not match what you would think their emotion to be.
That's going to become important when we're calling individuals as witnesses and juries or judges going to evaluate their testimony.
And I think that's key. I know, for example, I have a lot of clients who really get stressed about going through security at airports and things, because they recognize the higher stress they are, the less sort of that their facial expressions may match their emotions. I have a client who laughs quite a bit when we're talking about really uncomfortable things. I have a client who has, very flat affect, and his affect does not match at all what he's feeling on the inside. So I really have to be concrete about that. So if the affect, the facial expressions are not matching what you would think for emotion, that would be a red flag. Mm-hmm. Some people with autism, not all, but some have difficulty with varying their tones of speech, their the cadence of their speech. So they may sound more monotone than neurotypical people. Some people have found ways to script information. And so that means, and that's a tricky one to figure out sometimes, that means some people, even with advanced IQ, but more so I would think people with who have more difficulty verbally and with IQ, have found ways to pick up pieces of information maybe from TV shows, from movies, from video games, and take that chunk of information and answer a question using that information. So it's sort of in the right context, but a little bit off. And for some people, the social interaction is so overwhelming for them that they've found ways to shut down the social interaction pretty quickly. So answering a question without really answering it in order just to end the conversation.
Okay, let me focus on two other things.
Yeah.
One is eye contact.
Yes.
I'm also not so great at that, but carry on.
Eye contact and delayed processing I want to talk about as well.
Go ahead.
So eye contact, in our society, we tend to have a understanding that lack of eye contact leads people, look suspicious, looks that somebody's not...
if somebody's not making eye contact.
If somebody's not making, or I've had some people also who make extensive eye contact. So they've learned at some point that eye contact is a good thing, and they've taken that rule and really, really, really applied it. But typically, people with autism find looking at people's faces to be exceptionally stressful. It's a lot of information to take in, and some people have even told me it's quite painful. And so they are actually processing information better when they are not looking at you. Mm-hmm. So if they are looking away or looking somewhere else, you can trust that they are probably processing information a lot better than if they were looking at you. Often that taking in of information and processing it at the same time is too much. So eye contact, if somebody, that would be a red flag. If somebody has either too intense eye contact, like not breaking away, or no eye contact, may be a flag. And
I'm going to make eye contact with our audience notionally here for a minute, but you can see how this is important to be able to convey this information to a trier of fact, because otherwise they could misread all of these cues as signifying a lack of credibility or shiftiness. Anyway, sorry, go ahead.
No problem. Delayed processing. So a lot of people that I work with, again, even the very intelligent individuals, it takes processing information auditorily is typically their weakest way to process information, and therefore it may take from 10 to 15 seconds once you ask a question for them to answer a question.
So you could have a lag between the question and the answer. You can see how this will fit into a courtroom, and everybody expects an answer as rapidly as you're answering mine, but they may need a longer lag time.
Yes.
And what we, of course, lawyers and paralegals, because we're all talkers, we'll jump in there if they have an answer to start trying to clarify things, and that actually can work as overload. Right?
Oh, that would completely work as overload. That usually, if you're trying to rephrase a question while somebody is processing the question, you're just starting back at square one over and over and over again, and that can really cause somebody a lot of stress.
Okay, let's turn your attention to environment. We're gonna apply this all in the courtroom in a moment, but just talk to me about sensory integration issues.
So many individuals on the autism spectrum process their sensory environment differently than neurotypical people. So I'm just looking around the room here. Lights, sounds, smells, all those sorts of things can become quite overwhelming. I had a young person in to see me yesterday who told me, I said to him, "You had very good hearing." And he looked at me and he said, "I do not have good hearing." He said, "It is exceptionally painful for me. My hearing is not good." because he can hear everything to the nth degree.
So in other words, sound is the equivalent of as if you were turning the volume up.
Yes, and I like sometimes it's like things are the entire sensory environment is coming in at full volume. So if somebody's in a corner speaking, paper shuffling, lights on, buzzing of lights, all of those sorts of things can become exceptionally overwhelming for an individual. Smells can become exceptionally overwhelming, especially in a stressful environment. So I would imagine at court it would be a stressful environment, and those sorts of things would be amplified.
All right, so recognizing, of course, that this is a spectrum disorder, so some people may have all of this, some of this, none of this.
Yes.
It may be some of their senses are hypersensitive and some are not. So now we turn to the client or the witness and say, what can we do to make court easier for you? What accommodations might they need? Let's turn to that, please.
Well, for anybody, but especially for people with autism, unpredictability and the unknown in new situations are exceptionally stressful. And so it would be important ahead of time to give somebody as much detail as possible about who's going to be at court, what their roles are, what the process is going to be, and do that in a written format, either using visuals, which you can get online, picture visuals for people who may not be able to read, pictures of a lawyer, of a judge, those sorts of things. So really breaking it down, telling them when the breaks will be. So the breaks will be predictable. Individuals with autism would likely need more breaks than other people.
Right. Taking them to court a day before or a few days before to see the place.
Exactly, yeah, doing that. So meeting whoever they can ahead of time, seeing where they're going to sit, seeing the environment, so it's not as unknown. It gives them some grounding and some predictability is really important. Many people with autism do know their stress levels. They recognize things that would get them stressed. Some individuals, that can happen very quickly. They can become overwhelmed exceptionally quickly, and they may not pick up on the earlier signs. So you may have to talk to them or their family to recognize what some of their stress, like some signs of stresses may be, and have a break when they're exhibiting those signs, because an individual can, if they become completely overwhelmed, can shut down or have a meltdown, meaning not being in control of their behaviors. And it would be hard to get them back after that. So to preemptively have breaks when you see those signs. One thing that some people with autism do, most do actually, but some of the people who are maybe more independent and intelligent may hide it and do it at home. They do what we call stereotype behaviors or stimming behaviors. So
stimming meaning self-stimulation.
Yeah.
That term sounds sort of like, what are you talking about? Give us some examples.
Yeah, so I use the word stimming because actually many of the adults that I work with use it themselves. They don't find it a derogatory term. But stimming may be like soothing behavior. So some of the rocking that you may see of people who have autism, who may not see it in any other environment except when they're under stress. Hand flapping sometimes, getting up, pacing, all of those sorts of things are calming behaviors. Humming. So people with autism sometimes hum or make involuntary sounds, and that's actually a soothing. It regulates their nervous system.
What about having something in their hands?
Yeah. Fidget. People like me, I fidget with pens. But people with autism sometimes like to fidget with things in their hands to keep them calm. In my office, I always have things for people to fidget with. And some people have special interests, things that they know a lot about, and having an object on that represents that thing would be very important, especially in a court case. So not taking away any special objects.
And how do we find this out? We got an adult or a young adult with autism. They're expressive. You talk to them.
Yeah.
Who do you talk to?
I would talk to them and just ask.
What makes you feel easier?
Yeah. What are things that help you? I know for some people with autism, they have things that they know a lot about that calm them if they can talk about them, or if they can participate in that. So those things would be helpful,
right,
for them to be able to have access to some of those sorts of things.
So in the courtroom, accommodations includes having those kind of things for self-soothing, the orientation in advance, walking through the process step by step so they know what to expect.
Yeah, relying the wording that you use as a
Talk to
lawyer,
us about how to ask questions.
Ask questions in very concrete terms, black and white language. Do not rely on any assumption that they are going to.
Give me, when we say concrete, what do you mean?
No.
Be concrete about being concrete, please.
So not reading between the lines. So I can't think of a figure of speech right now. But we often socially rely on figures of speech. We sort of talk around topics. Maybe not in the court as much, but in the black and white, very concrete. What happened on this day? Can you tell me specifically? Around times. I think times and dates and to orientate a person to exactly when you're speaking about. The other thing I also wanted to mention around the idea of memory. People with autism tend to, it's a generalization, but tend to have fantastic visual memories. They tend to be able to remember information in detail. However, they may pick up on other aspects of a situation or environment that neurotypical people may not typically look at. If there is something happening, if there was a car accident, for example, or a bike accident, they may be really keyed into the wheel turning and not the bigger picture. So their memories, I think, are highly reliable, but
may be focused on data that other people aren't focusing on.
Exactly, the details. So you may have to ask specifically, what details you are looking for, the context.
If I want a professional, if I needed who assesses or diagnoses autism?
In children, it's usually a developmental pediatrician. In older kids, it's usually a psychologist or a psychiatrist.
And what are the stereotypes that juries, judges, or others who are making decisions and hearing their evidence might have about autism spectrum disorder? What are the common stereotypes out there?
One, I think I commented earlier on that communication ability doesn't necessarily equate to intelligence.
So in other words, if they're having trouble communicating, it doesn't mean they're not intelligent.
Exactly. And this idea of high intelligence or high functioning, I don't like the language high functioning, but high intelligence does not also necessarily equate to being sort of independent. There are some people I work with who are highly intelligent, but their levels of anxiety and sort of understanding of day-to-day functioning impacts them more than people who would have a cognitive disability and may have less anxiety. So not to rely on the idea of intelligence so much, to look at one's ability to function. And also, Rain Man did the world a lot of good in getting the
movie Rain Man, right.
And getting the information about autism out into the community, because it was relatively new then. But savant skills are exceptionally rare, and
so this image that if somebody's on the spectrum, that they can tell you how many paper clips just fell on the floor or whatever.
That typically, I've met a small number of savants, but I think Rain Man made a lot of people believe that was a common thing with
All right, if I want to educate a judge or jury or tribunal about autism spectrum disorder because someone's going to testify, and I want to equip them with the skills to be able to not misunderstand their evidence, not see the lack of facial contact or eye contact is undermining the credibility. Who do I get?
I would think typically a psychologist would be the ideal person to give that information.
Okay. Any other tips for our audience before we move on to our third disability area that we're going to talk about today?
No, my biggest tip is just to rely on your words rather than facial expressions and body language, processing time and
processing time meaning pausing
and giving very concrete information.
Very good. Thank you. That's great. Let me ask you to just slide back a little, and Gail. You're going to talk to us today about traumatic brain injury. So let's start with asking you who you are and what do you do?
I'm an occupational therapist working in the area of neurorehabilitation for the past 20 years. I'm currently working in private practice in Toronto, so I'm an independent practitioner. I was a clinical practice leader at Bridgepoint Hospital, and so I've seen a lot of clients as well as looking at setting up programs for them. I also did a master's in health administration just to look at the system that patients go through, especially with traumatic brain injury.
Okay, tell me, so what is The name seems like it tells us everything we know. Traumatic brain injury. Somebody's got an injury to their brain. What is it? How they get it? How many people have it?
It's interesting that you would say that. So traumatic brain injury, and you're right. It's the term now is synonymous with acquired brain injury, which is the term that used to be used previously. And it is actually more a continuum. I'm thinking about...
I'm just interrupting for a minute.
Sure.
You're talking relatively quiet. I just want to make sure our audio
okay.
is going to be strong enough that we're picking you up. Just cueing our AV people here.
Okay.
Anyway, you carry on.
I'm a bit of a quiet talker. Okay. Traumatic brain injury, we would probably look at that more as a continuum. We've seen a lot in the, especially in the media, about concussion. You know, there's a lot of research going on with that. So traumatic brain injury is anything that occurs that's an external force, anything that's acceleration, rotational force, as you'd see happening in a car accident.
Applied to someone's head.
Absolutely, yes.
Right.
Certainly we see a lot of that in sports. We see that with a lot of the war vets, and I think a lot of the states has been following that because of the amount of injuries in that area.
But if we're not sending a lot of our young people off to war, the main causes here would be sports, car accidents. Sports
and car accidents, absolutely. Falls and car accidents are about 75% of traumatic brain injuries in Canada.
Okay, and concussion's part of that?
Concussion is part of that. Concussion is interesting in that there is now some programs in the school, the concussion programs, to be able to identify that sooner. The issue with concussion is that if it isn't dealt with sooner and children or whoever sustains one is taken out early enough from the activity, they can have some long lasting sequelae.
So not every concussion causes TBI, but some can.
Absolutely. So a concussion you should see resolving within a month to 3 months. If by 3 months you still have some symptoms, which would be things like fatigue, memory problems, drowsiness, attention issues, problems with emotional control, they call it, information processing, then you would look at something which is called post-concussive syndrome, and that occurs in 15% of concussions.
Okay. So you've talked about the causes. What kind of numbers are we talking about?
So in Ontario, there's about 88,000 traumatic brain injuries per year. There is currently...
that's per year, so that's adding up over time.
Yes. And they're finding that it's increasing over time. There was a study done that looked a couple of years ago that looked at children with brain injuries between 2003 and 2010. And it actually, for girls, it had doubled. The rate had doubled. So that's one of the reasons why it's so necessary to have a lot of things to put in place, helmet laws. Charles Taylor is a neurosurgeon who's very active in putting a lot of these things together.
Okay, and what kind of age profile for onset? Obviously, once you've got it for your life, but what are you seeing in terms of the age profile of people who acquire these?
There's 2 spikes. It's the younger group and the older group. So in the younger group, it's mostly falls in sports. Some of it is related to...
By younger, you meaning teens or 20s?
Teens. Actually, they look at it from 0 to 4, and that can be is often falls, or it can be from domestic abuse. Not as much from car accidents. When they get into the teens, you're looking at recreational sports, as well as falls related to perhaps that or motor vehicle accidents.
Right, and the other spike?
And the other spike is 65 and over. The biggest spike is probably around 85, and that is primarily from falls.
From falls.
And that's due to having decreased balance and some of the issues that come with aging.
And again, as with all the conditions we're talking about today, we're talking about a spectrum of different manifestations, but give me the kinds of symptoms that can appear.
The biggest symptom, and I think of with MS and autism, we're looking at neurological symptoms or neurological disorders. So there's a lot of similarity. I think the key one probably is memory for traumatic brain injuries, decreased ability to attend to situations. So, for instance, there would be some difficulty with, working at your computer and your phone is ringing, and that could be something that could throw somebody off. It's something called executive functioning, which is ability to problem solve, set goals, and make decisions. So that's often a bit of a difficulty. There are issues with fatigue and physical fatigue as well as mental and emotional fatigue. There's also issues with insomnia, so you might find that people aren't sleeping well enough, and that's exacerbating some of their cognitive issues. There's the obvious more physical issues that they can have, which can range from something as small as fine motor skills to balance, or you may find someone who's hemiplegic who can't use one side of their body, depending on the degree of injury.
And does it go away, or is it pretty much that way for the rest of their lives, or?
Well, that's the thing now that they're talking about a lot more. 20 years ago, they talked about the concept of neuroplasticity and that the brain had the ability to regenerate and to reform neural pathways. And they're finding that in the last number of years is I would say 5 or 6 years, is something that they're seeing more and more. So there's definitely improvement. It used to be that we would look at improvement within the first 3 to 6 months. We realized that was too soon. And now we're looking at improvement happening over a lifetime.
Okay, now we've heard 2 different presentations. One is about MS, which can vary day to day,
Yeah.
and the autism spectrum disorder, which obviously is going to be more of a constant in the individual's life. What is it like with a traumatic brain injury? Do they have these memory issues, fatigue issues, and so on every day, or is it vary day to day and is unpredictable?
I think comparatively it's probably not as unpredictable as MS. The memory issues are pretty consistent. The things that would vary would be perhaps if they haven't slept well, level of anxiety, depression. People with traumatic brain injury are 7 times more likely to have concurrent mental illness or something that happens that way. So that may change on a day-to-day basis.
Right.
Yeah.
And so let's take this information now and translate it to the court setting. What, for one thing, how would a person with a traumatic brain injury present themselves if I'm interviewing someone as a witness or a client? What are the flags that I'm going to notice? And to what extent do the folks with traumatic brain injury self-identify? No, they do. How is it discussed? What language do we use?
So initially sometimes you'll see with traumatic brain injury that there is a lack of insight into what's going on, and that's basically from the injury itself, especially if it's a frontal injury. Mm-hmm. And usually over time, if it's a severe injury, you may find that they do lack some insight, in which case they may not be someone who would necessarily be a witness without some sort of assistance already known. Mm-hmm. Usually their insight, they're acutely aware, painfully aware of some of the difficulties they have and that they struggle with. You may find when you're interviewing them that they have either they pause frequently, as I'm doing now, but they pause frequently during the question because maybe they're not taking all the information in. Right. Maybe they need a little bit more time to think about things. Maybe they're being overly stimulated by the environment. Again, just like with with MS and with autism, if they're in a brightly lit room or if there's a lot of people around them, that can affect them. You might find that they are just looking at you while you're asking them questions, and it doesn't appear that they're hearing you, but really it's just they've been overwhelmed by the amount of information that they're being asked to present.
All right, so what do we do and what terminology is good for us to use? How do we ask?
I think the best way to ask is there something we can do to make things easier for you, or is there something that, it's usually the idea of asking them what they need functionally rather than asking them, assuming that because they have a traumatic brain injury that they're going to have a struggle with something. So usually right. I find that's the easiest way to ask them. Is there something that you'd like in written format? Is there an easier way? Would you like a break?
Right.
Yeah.
Okay, so what accommodations should we be asking the courts to make, or should we be trying to arrange to make things easier? Or what steps can we take to make things easier for a client or a witness with traumatic brain injury?
I think the preparation for trial is one of the most important things. I do work with a number of clients that have been in motor vehicle accidents, and one of the things that's most stressful for them is not knowing what the courtroom is going to look like, not knowing what the questioning is going to be like. They really do need detail, as discussed with, especially with autism. that's something that'll create anxiety for them. There can be with brain injury a little bit of rigidity of thinking, and I don't like that term, but it's that idea where, again, you know, it's difficult that they need sort of a concrete way of looking at things. Mm-hmm. Going to see it ahead of time would be really helpful for them.
You talked about fatigue. Is
Yep.
this like the situation with MS where we should be looking at more frequent breaks or not necessarily having the case go for full days?
Absolutely. And I'm trying not to repeat some of the other ones, so I'm kind of thinking of my whole list of ones. But that would be definitely one where breaks would be great, especially known breaks. This always makes things a bit easier. Because fatigue is one of the things that my clients tell me makes the courtroom sessions most difficult.
In the context of MS, there's the possibility of having better times of day. Is it the same with people with traumatic brain injury?
Yes, absolutely. And again, they may have attendant care. Usually it's in the morning, so afternoon is always better. Trying to set those...
But are there times of day when concentration and memory and everything is better,
well,
or fatigue is worse?
That's the unfortunate part, is that if a client has slept well, then mornings are often better. Often that's when they have attendant care to come in to help them if they have any physical issues. So it's kind of a bit of a situation where it could be arranged. We have had arrangements where someone has come in at 6 in the morning to help a client get ready, and then, of course, they've been up for a number of hours before they go to court. So those are just some of the things that can be an issue, but it is always better if they can do it, I think, later in the day, unless if they can have a time to rest. So we often say that they need to nap and rest whenever they can.
And what about me as a lawyer asking them questions
Mm-hmm.
in the courtroom? I'm calling their witnesses. Are we in the same area that we heard about from Stephanie for autism spectrum disorder, concrete questions broken down?
Absolutely. Absolutely. The more information that you give, the more confusing it can be. So if you want to ask a question, it could be something like, did you see the other car coming? Is better than, can you tell me what happened in the accident? And I know that it's usually, part of the idea is to have it open-ended, because you want to find out what their recall is. But sometimes they will there's too much for them to think of. They'll forget some things they need to include. Not that
Right.
It's not there. I often say that memory, it's like a computer file, that the information is still in there. It's just they need to have the password or the trigger to try and get the information
To
out.
retrieve it.
To retrieve it appropriately, yeah.
Okay, stereotypes that a judge or jury or tribunal might entertain if they come to understand that a person has a traumatic brain injury.
I think one of the biggest stereotypes, and you see this, there's a lot of websites that people with traumatic brain injury have, that people look at them as being intellectually slower, that they don't have the ability to problem solve or give information or have that knowledge. I think that's one of the biggest ones. Another one would be that it's not actually it's not a real thing, that they're actually pretending, and I think that's one that can be very stressful with such an invisible injury, that people often don't expect that they're going to not be able to recall some information, or they may have an emotional outburst, or they may be more anxious than usual, or may require some more accommodations than you would think from someone with a brain injury.
And if we want to educate the court or tribunal, what kind of professional should we turn to explain all of what you've been talking to us about?
Neuropsychology is often who does the assessments for traumatic brain injury, and of course occupational therapy. So often we look at a lot of the accommodations for both physical and cognitive issues, from environmental mobility issues to cognitive strategies and ways of making the information easier for them.
Very good. All right, thank you very much. You've all been extremely helpful, and I want to thank you. We're going to now turn to our second panel, get our presenters up here. If you're not up here yet, or are you up here yet? For our, thank you, you've been really, really helpful. We're going to now turn from learning about these three conditions, and in our earlier programs we talked in greater depth about a wide range of different other conditions that can recur. I want to turn now to what the Ministry of the Attorney General has been doing about it. To their great credit, they've they've appointed, at the recommendation of the Court's Accessibility Committee and the prior Weiler Committee, they've appointed a court access coordinator in each major court facility, and they're supposed to be the one-stop shopping place that you can go to ask for in advance for particular accessibility needs to be addressed. And if they're not going to actually do it themselves, they can route you to who can. So those folks are spread out around the province, but also at the head office at the Ministry of the Attorney General for Ontario is an accessibility unit staffed by a number of good people, two of whom are present, Jill Sawchuk to my immediate right and Laurie McAvoy to my further right. And that's not a comment on anybody's political disposition, I promise. And they've both been working in this field forever, close to forever, and doing, I might add, without hesitation, an absolutely fantastic job and really quite dedicated to it. So we've had a chat before we came up here today, and I got some questions. Just throw it out, and the two of you just decide who's at the plate and who's going to swing at the pitch. Actually, let's just start with what each of you do. Jill, can you just tell us what you do over at the ministry?
Yeah, so at the Ministry of the Attorney General, I work in a unit called the Accessibility Unit, and we are a corporate service that supports the whole ministry in compliance with the accessibility-related legislation, human rights legislation, and one of the things that we do as well is we provide support and advice to our accessibility coordinators who are in our courts.
So they're on the front lines. If they've got problems, they call you.
Yes.
Right. Laurie, you do the same thing, or you do something different?
I do the same thing with a twist. No, I do the same thing.
Got it. All right. So talk to me, folks. You've got court access coordinators around the province. They got people coming to them asking for help, disability-related help in the court process. It may be a lawyer, it may be a paralegal asking. It may be an individual who is not coming with any representation at all. Can you give us a sense of the breakdown or percentages of requests they're getting? It'd be helpful for our folks watching this program to know what accommodations are the biggest demand ones that at least that they're hearing about.
Yeah, certainly. I mean, first, before I get into that, I do want to reiterate, and it echoes the comments from our other panelists, is that, you know, every case is individual, depending on the needs. But there certainly are the more frequent and common requests. But certainly, by far, the most frequently received request is from people who have hearing-related disability. And so some of our recent stats over the past year and a half indicate that over 70% of our requests come from this population. And so we would respond in different ways. They have varying needs. Assistive listening devices for people who are hard of hearing. Those are devices that help to amplify the sounds. The most common and frequently provided. Second, with sign language interpretation.
Okay, and captioning on occasion?
Captioning is also a very common service provided for people with a hearing loss, just not as common as the others.
So that's the biggest one by far, hearing loss. Mm-hmm. What's next?
Well, then physical-related disabilities, so some type of physical disability mobility, and we don't capture things based on the disability name or diagnosis, so I'm going to just kind of give broad categories. Mm-hmm. So physical disabilities, mobility-related disabilities, we're down at about 10%. Learning disabilities is also quite common at about 6%.
What kind of accommodation? We've had a panel at one of our earlier programs. What kind of accommodations do they?
I'll be talking to one of those.
Okay, good. Okay,
yeah.
good. Okay.
And then, you know, everything else is just the range of disabilities. There's mental health disabilities, vision-related disabilities. And I think one of the things that the caveat to this, though, too, is this is based on our stats. And these are the people that come and identify a need and make a request to an accessibility coordinator. There could be many other people with disabilities in our courts. They just don't happen to need something in particular, or their needs just get met in court.
They could. Yeah. There are other people who may just ask something of the judge, or counsel
Correct.
ask something of the judge. It doesn't go through the access coordinator.
Yeah. So we don't have a way of tracking that.
Right.
So.
Okay, well, that's very helpful. Now, much of these programs we've dealt with up till now have dealt with recurring requests that are not that in many cases, aren't that complicated. You need sign language. We order sign language. You need captioning. We order captioning. It's not to say it's a simple thing to do, but it's the need is identified, and that's it. What I'd like to turn both of your attention to is instances where you get more complicated requests, because counsel or paralegal who are watching today may encounter a client or a witness who has more complex needs. People may have more than one disability, or it may manifest itself in a more difficult or complicated way than the way we've covered in the panels up till now. Tell us, can you both give us some examples of those and what's been done?
Yeah, certainly. So Lori and I are going to talk about, I think, about 3 or 4 different examples. But to your point about what makes something complex, it could be that there's multiple disabilities or multiple needs, and there's multiple accommodations that have to be made. So it's not just a sign language interpreter. It may be somebody who's deaf and blind and needs a number of different things to happen in court. And Lori's going to give some examples of that. It could also be, it might make things complex where there might be a lack of readily available resources in a community. So somebody might need a sign language interpreter, but they're in a small community. It just takes more time and advanced planning to get the sign language interpreter there when needed. And so it may need to be a rejuggling and rescheduling. So that adds to the complication. The other thing that can make things complex is when we don't get enough advance notice. So especially when we have to coordinate with multiple people. So I'm going to give an example of one of the more complex ones that we've dealt with. And it relates to a scent sensitivity or a multiple chemical sensitivity. Now, we don't get a lot of these requests in courts. It only really represents about 1% over the last 1.5 years. But this type of disability is it can be called an environmental sensitivity, but somebody has a severe allergy or health condition that is triggered or aggravated by some kind of airborne chemical. We commonly hear about it in terms of perfumes or off-gassing from carpets. It could be dust or other different scented products. Cleaning materials is another example. So there's a range of reactions that people can have to these. They can be mild all the way to severe. But it can show up in different ways. Somebody might get migraines. Somebody may get foggy and have a difficulty concentrating. Somebody may actually get physically ill. And there can also be a lot of anxiety and stress. So, depending on how severe it is, the reactions are going to be different. But the goal of accommodation when this is identified usually is to minimize or avoid that trigger or substance altogether. So when we get that type of request, we usually look to options such as, well, can you participate remotely? Can you participate by the phone? Or can you participate by video conference? And sometimes that's appropriate, but other times it's not. And we do need to find a way to get them into the courthouse and accommodate them there. So we had a recent case where there was an individual who was involved in a family matter, and now he's a self-represented litigant. The other party was represented, and he identified that there were issues with off-gassing of the new carpet and new wood paneling in the courtroom. So they identified that that would be an issue for this individual. So the accessibility coordinator worked with the individual to try to explore more about what might work in this particular case. They couldn't participate remotely. So they went to different areas of the courthouse to try to find a room where they could control the environment better. And they looked at a couple of different options. The individual came in ahead of time, and they ended up finding a room where the floors were not carpeted, the walls were a mix of concrete and drywall. So there was no issue with the carpeting and the off-gassing. And what they ended up having to do is set up court in that room. So it meant bringing in tables, bringing in chairs, bringing in the digital recording equipment, working with the police because security was an issue of making sure the police were available outside that particular room. This was all coordinated in advance with the judge, making sure that the presiding judge was okay with exploring options. And through that process and through the judge also identified that the other party needed to do some things. So the other party's lawyer made... You
mean the opposing party?
The opposing party's lawyer also took some steps to notify their witnesses and their client that they shouldn't be wearing any scented products. all staff who would be involved in the proceeding in this new different courtroom were also asked not to wear scented products. So
you could do all this work, and somebody who's not connected up with can decide that they're going to take their bottle of cologne and splash it on in abundance, and it jettisons everything you've done.
Yeah, I guess so. Yeah. So, so in this particular case, you can see that I think you can imagine the amount of advanced planning and coordination that was required. And I think in this particular case, everybody was really pleased with how it went. And in particular, the staff and everybody involved were certainly willing to pitch in and do what they can to make this happen. And we're pleased with the flexibility that occurred to put this in place. But
if we've said this a zillion times, I'm going to make it a zillion one. If you show up the day before and say we need a scent-free courtroom, you can't pull all this off.
That's right, right, and so we wouldn't have been able to do that in this particular case, and we certainly it would have made it even more complex if people weren't agreeable. All the different parties weren't agreeable along the way. It doesn't mean we couldn't do it. It just would have been more difficult. But I think it shows that when everybody is aware and willing to respond, that things are quite doable, even if it takes a little bit more work.
For those who are watching our program today, what else are we doing for the environmental sensitivity stuff, or should people just avoid scents generally? That's spelled S-C-E-N-T-S, generally.
So as a ministry, we are exploring different strategies. There's been a range of examples across all of our courthouses where people have put in place different strategies to meet a specific need. So there are a lot of examples where our employees have a scent sensitivity, where our presiding judges in some locations also, and even council members who are coming to court regularly. So you'll see different strategies that are in place to meet a particular need, but we are also looking at ways to encourage members of the public and the regular court users to watch what they wear and to be aware that personal scented products can, in fact, make people ill. And so we're asking people to respect that and be aware.
Has the ministry looked at this point, or has it established a court in which fragrances are not to be used so that we could try to route cases in there in each building, or has that not happened yet?
That is not a particular strategy, but it may be in place in some of our courthouses to meet a particular need.
Right.
Yeah. Certainly we respond to requests individually, and the one thing to remember of the case that I provided is that that's happened to be what was needed for that particular individual and what could be put in place in that particular courthouse. That option may not have been available in another courthouse, and sometimes we look to bringing the court off-site to try to find
create a court site, essentially elsewhere. A makeshift court site somewhere else.
Yeah, exactly.
All right, other examples.
Okay, so I have three. One was an assessment hearing for an individual who's deaf-blind, a master's court proceeding for an individual who is unable to hear or speak but does not use sign language, and a small claims hearing with a plaintiff with a disability affecting information processing. I think it was spoken to earlier, somebody who needed time to be able to process the information and respond. So I'll tell you a little bit more, but I'm going to start with some terms just so that everybody knows what we're all on the same page. So deaf-blind is basically a person who has a substantial degree of loss in both sight and hearing. There's a range, as there is with many disabilities. Some people may have no hearing and no sight, or there could be a range up to, some people may have a little bit of sight and no hearing, a little bit of sight and some hearing. So it ranges, and so people's needs are very unique and different. A deaf-blind intervener, this is basically a professional who provides both oral and visual information to the individual who's deaf-blind in the way that works best for them. So they're kind of like a sign language interpreter, but they're dealing with both information the person would need to see and information the person would need to hear. Generally, there's a number of different strategies, and again, it would be based on the individual as to what strategy is used. There's manual techniques for, signing to the individual. Somebody might be able to see sign language, so very close up. So if they had sign language skills, you could use that. Other people may use Braille or be able to use large print. So whatever works for the person is what the intervener would use. Real-time captioning is something else I'm going to talk about, and that's also often referred to by some people as CART, C-A-R-T, or the full name is Computer-Assisted Real-Time Translation. And that's basically, you're actually seeing it on this webcast today. It's basically a professional is typing shorthand, short forms into into software, which expands the short forms to full text. And then you can read along with the text. So that's real-time captioning. And then one of the other, and this is a rather a newer service that's available more recently in Ontario, and that is communication intermediaries. And these are basically sign language professionals who have been trained in court procedures and court proceedings.
It's actually speech and language professionals.
Yeah, so they are able to assist in various ways depending, again, on the communication method that the person uses. So case example one was a ministry client who was deafblind. He had already been in court and had court experiences and had been very frustrated. And obviously had difficulty participating. So he did call the accessibility coordinator. He had both significant loss in hearing and significant loss in vision. He mainly relied on his hearing, so amplification, but also used a deafblind intervener to actually speak into his ear for him. And so that was his method of communicating generally. We suggested we meet ahead of his court proceeding to discuss with him how this might work. This is a case where he didn't really know exactly how we would do this or how we would be able to accommodate him. So we did meet with him and his intervener in advance with the court staff, both the staff who was going to be in the hearing, the accessibility coordinator, and someone, and I went as well. And we had the discussion, and what we figured out was that it would actually require a series of accommodations working together. So he would need to use an assistive listening device, which again is an amplification system that hooks into the microphones in the court. He would get some better hearing through that. And the deafblind intervener would be there to go back over anything if he was missing. And the deafblind intervener would need to have the captioning to be able to go back a little bit and explain anything that he flagged he had missed. And it sounds quite complicated, I think, and there would obviously need to be some extra time and extra breaks because of this communication method. But we did hear back on this from the judicial official that was hearing this, and it went well, it worked. And so there will be an actual trial coming up later in the year, and they will be using this for the trial as well. This was initially used for an assessment hearing, but they will be using it for the trial as well. So there you've got a case of somebody who can't see what's going on in the court, can't hear much of it, or can't hear it fully, even with accommodations in place, and yet there was a process that worked by merging several different accommodations together. And
I'm going to have you move through your other two examples quickly because we've got time constraints.
So case number 2, it's fairly similar to the first one, but it was an individual who requested accommodation for both hearing and speaking in master's court, but they did not use sign language. This one was a little bit more challenging because our communications with the individual were by email. We weren't always getting answers to all our questions. At first, it sounded like he wanted to be able to write out what he wanted said and have someone else read it. Later on, by the end of when we were getting to arrangements, it was he did want to use a laptop to type his answers, which, again, if he had enough skill, would probably make things go faster. So, again, in that case, we used real-time captioning. So that he could read what was being said because he didn't use sign language. We used the laptop, and we again offered either the option of him bringing someone possibly who could speak for him in anything he wrote, or using a communication intermediary to speak. Again, additional time was needed, would be needed for breaks. So again, this one is kind of one where you might want to have them come in early and try it out just to see, is the typing skill there? Are they familiar with the laptop keyboard? Just so something like that doesn't throw somebody off at the last minute. So, and the final case I wanted to speak to was a case of a woman with a disability that affected her processing auditory information. And so she was able to comprehend information if she was given written information and then the time to process it and go through it. She was involved as a plaintiff in a small claims matter. And in this case, there was no judge assigned at the time, or deputy judge. So we did, the court staff went through the administrative judge, who was able to give direction to say, yes, we can proceed with offering accommodations. So what the accommodation offered was that the deputy judge would listen to the defendant's arguments of the case, that the defendant was arguing that the case should be dismissed. And the deputy judge would then write an endorsement and a list of questions regarding the information he wanted the plaintiff to respond to or provide. And so the plaintiff would be able to take the endorsement away, have time to process it, have time to write responses, and then reply to the court. So that was, at the time, I think one of the first times we'd had that done. So that was quite an exciting case. And again, it's got to depend on all the factors of the case before that's going to be decided.
Understood.
But it was.
All right, I'm just going to ask you folks one last very quick question, and then we're going to have to proceed to our next panel, and that is, there are court access coordinators at each major court facility. How does somebody find them? How do they find them online? How do they find them if they're just walking in the building?
Okay, so with the materials that were provided
For this program
and for today, we provided some information on the coordinators and a link to our website that provides more information about the accessibility coordinators, as well as a link to all their contact information, and you can search by court location. Or if you're in a courthouse, you can ask any staff member who's the accessibility coordinator, and they will be able to direct you to them.
All right, very good. Thank you very much. Now I'm going to pivot to my left. We've just been joined by our last panel, who will be giving us the perspective from the decision maker. We are joined today on my immediate left, unless somebody's changed the seating plan to make fun of me, with Howard? Yes. It's Howard Bornstein, Justice Howard Bornstein. I have had people change seating plans on me, but in any event, who is
we would have done it.
That's true. Who is was defense counsel and then has been sitting for a number of years on the Ontario Court of Justice, hearing criminal cases in Toronto. To his left is Anne Malloy, who was in private practice and legal clinic practice and government practice, doing a number of issues, including a good stint as a fabulous disability rights lawyer, and is now, and for several years, has been on the Superior Court of Justice in Ontario. I won't ask how many years. And finally, David Wright, who was in labor law practice and is now the chair of the Law Society Tribunal, and previously was the associate chair of the Ontario Human Rights Tribunal. So we're going to get a court perspective and a tribunal perspective on all of this. So let me begin, and I'm just going to throw it open and let you all decide who should speak in what order. But if we can just sort of just jump in and tell me, at pre-trials or pre-hearings, do you ask parties if there's anyone who needs accessibility or accommodation because of disability, and if so, what kind of answers have you gotten since you've gotten involved in this? Justice Bornstein, to begin with.
Well, we do. On every one of our judicial pretrials, we have a series of questions that we ask counsel, one of which is, are there any witnesses or does the accused require any sort of accommodation? So we ask that in every case.
And what kind of answers have you gotten?
In 10 years, I think I've probably received not more than one request for an accommodation at the judicial pretrial phase.
Not that you're sitting in judgment of the thought process in front of you. To what extent are you do you get a sense it's been considered before, or they're just thinking on the spot?
My sense is that they're thinking on the spot because, as we know from the numbers we heard at the outset, that there's a substantial number of people in Ontario who would require accommodation, many of whom obviously would end up before the courts, and it's inconceivable that none would require accommodation in a judicial pretrial. Now, it may be after the pretrial counsel then turn their mind to it and put in the request to the various
Your question may be the thing that jogged them, but that's significant. Justice Malloy, what about you?
Exactly the same.
You ask and you...
I ask every time. Nobody's ever indicated there was a need for an accommodation. But my experience has been sitting in trials that I am almost never asked for an accommodation at that stage, and yet I see accommodations have been done. So I think it's, as Justice Bornstein said, the trigger is they're asked at the pretrial stage, they go away and think about it, and then they set it in motion.
Something gets
it does
happening.
happen.
Right,
yeah.
Okay. David.
Well, most of my adjudicative career has been at the Human Rights Tribunal of Ontario, where in the application and response forms, the tribunal asks about accommodation needs. I think in mediation, which is the Human Rights Tribunal equivalent of a pretrial, generally people aren't thinking about their witnesses yet. So at the pre-trial stage, often people are thinking about the parties. And at the Law Society Tribunal, again, those issues might have been identified earlier, because in our process, we're never seeing people for the first time. They've been involved in a law society investigation. But the kinds of accommodations that we've been asked about include everything from breaks to allow people with different types of issues to have those regular breaks. Just being aware that people with chronic pain, for example, may need to get up and walk around, accommodation of sign language, captioning, location, all those kinds of things. And I think they come up at all different stages of the process. And sometimes, and I know this has been said in some of the earlier webcasts, sometimes the last minute is when we get them, and we understand that that happens. But the earlier, the better, and the earlier, the easier to accommodate them.
All right. Let me just Lloyd, I'm going to follow up with you. Just what David Wright was just talking about. What have you seen being delivered in the way of accommodation in your courtroom? Give us a sense of some stuff that's been done and been done successfully.
Most common thing by far is audio enhancement.
Right.
And I rarely see much else. Some physical placement. Of course, our courthouse, I sit at 361 University, and it's hopelessly inaccessible within the courtrooms themselves. Only some of them have been converted, and we're in the process of doing it. But what I've found is that apart from the audio enhancement issue, there are a few physical accommodation things that come up, but they are always taken care of. It's never been an issue. One of my colleagues had, outside Toronto, had a big trial with a need for sign language interpreters for everybody, the accused, the complainant, witnesses. But they gave advance notice, and that all was accommodated. I spoke to the trial judge afterwards. It all went extremely well. So there are those odd things that come up from time to time, the more complex ones, but by and large, things have been taken care of before it gets to me, which is a good thing.
Yeah, absolutely.
You were delicate enough not to tell me, not to blow my age at the very beginning, but I've been a judge for 21 years. And when I first started, I would be seeing problems with a failure to accommodate people all the time. And I don't see that now because it is being taken care of more effectively.
Justice Bornstein, how about your courtroom?
Well, in preparation for this panel, I spoke to some colleagues, and despite the fact that at the pretrial people don't seem to request accommodation, there have been some very interesting and creative accommodations. For example, one of my colleagues moved the preliminary hearing to a nursing home with the entire staff, obviously, to accommodate a witness who was unable to leave the nursing home. Another colleague had somebody with a severe anxiety who didn't want to stand up in court, and it was an accused. So I had that person remain in the back of the courtroom seated during the proceeding. Obviously, there have been things like trying to, with somebody with a wheelchair, try to deal with the obstructions in the courtroom and the sight lines, and that's been accommodated. Somebody did a case where a witness was able to give evidence via Skype so that they didn't have to leave their home. Another colleague who had an accused who, to participate in the proceeding, had to be able to hear because nothing else seemed to work in that case. And she was able to exercise some influence so that legal aid paid for some hearing aids. And the person was able to participate that way. Finally, I had a case where somebody was unable to speak or hear and was making some brief submissions in court. And so what happened there, nothing was sought in advance. But he would write out what he wanted to say, hand it to me. I would read it into the record. I would write a response, read my response into the record, then hand it to him, and we went back and forth like that.
Right.
So those are some of these accommodations that I've seen.
More complicated ones. We just heard from the folks in the ministry who, obviously, they're at headquarters, so the most complicated things in the province come to their attention. Have any of the three of you either had more complex ones or heard of? Or the ones you see tend to be the more routine ones that you've been talking about?
So as an administrator at the Human Rights Tribunal, obviously, by definition, we're dealing often, about 50% of the cases at the Human Rights Tribunal of Ontario involve disability. So there are a lot of accommodation requests that do come in. Some of the interesting ones are actually around sensitivity as well. I believe we had a mediation where the mediator didn't use unscented detergent or may not have washed clothes for some time in order to avoid any kind of scent sensitivity. Some of the issues come sometimes around filing as well, in terms of literacy issues. You know, how can we assist people in reading letters to them or getting information back from them? A lot of it happens at the administrative level. In the hearing room, I think a lot around time of hearings. So I've certainly had hearings that go the morning only, that move outside of regular locations.
So in other words, you sat half days to accommodate stamina issues, or?
Yes.
Okay.
Or medication issues. Sometimes people who are taking medication, in particular for chronic pain, the medication may affect their cognitive abilities, and so making sure that you time things around that is important.
Right.
We've done that as well. For people in custody, we've even had nurses come to the cells at regularly scheduled intervals to administer medication that has to be given by needle, because they didn't want somebody down in the cells with a needle.
Right.
But we've had a lot of those things I only find out about in passing. Like I knew about that one because we were sitting a little late and somebody tugged on me and said, well, the nurse is here now.
Right.
And so I discovered that. As I said, things tend to just be happening now. I don't
More so
tend
than
to
before,
need to intervene very often.
Justice Bornstein, how about you?
Well, really nothing to add. I mean, we can break every hour, and we have done so to accommodate people. But it's pretty apparent from the speakers that you've had today, and certainly from my experience with staff and with counsel, that there's a real desire on the part of counsel, the staff, the judges, to do whatever they can to allow someone to participate, to accommodate.
Right.
And if you need it, people will move mountains to try to help.
Have you folks, any of you, had a situation where, or heard of a situation where counsel opposed an accommodation? In other words, one side asked for it and the other side said, we object.
I have. I've had it happen in criminal trials, and I've also, a colleague of mine had it in a civil case. So in the criminal context, sometimes, particularly where there's a jury, the defense counsel will object to a complainant, say, in a sexual assault trial, having requested accommodations, like testifying behind a screen, testifying in a separate room, and argues, the defense counsel sometimes argues this is not necessary because the person is, faking symptoms or whatever. Mm-hmm. And I must say that is very much old school now. That now that counsel are becoming more familiar with those techniques, I'm finding fewer and fewer objections to it, but every now and then somebody does argue that, you know, it interferes with their ability to cross-examine effectively and so on. The civil case that came up was a situation, again, it was a jury trial, and the plaintiff was personal injury case, and the plaintiff was alleging that she had some trauma as a result, some ongoing trauma, and wanted a support person present and wanted breaks and all kinds of things to accommodate what she said her injury was. And the argument by defense counsel was that giving her these accommodations was essentially telling the jury that she had these disabilities, when the whole defense was based on the contention that she was malingering. Mm-hmm. Now, unfortunately, in that case, the accommodation was not granted. I think, if I could be so indelicate, a better way to handle it, in my view, would have been to have the jury give an instruction, the judge give an instruction to the jury that this accommodation is being provided without making any finding about the existence of the disability, but merely recognizing if the disability existed, these would be appropriate accommodations, and that is an issue for the jury to decide. So just to be on the safe side, all of the accommodations are being provided, but there has been no decision made. Right, so that in those circumstances, a jury wouldn't infer from the provision of it that they must be genuine. That's right. And on the other hand, because if they were genuine, then their request for the accommodation is pretextual, but the instruction would cover that in a sense. So now that's helpful. Let me, just because time is tight, I want to just turn to two other quick areas. One of which is we've been talking through it for the most part about a situation where both sides are represented. Obviously, there are many cases that come before you folks where one side is not. If one side in a case is represented and the other side is a person who appears, who's self-represented and may have a disability with accommodation needs, any advice for counsel? If you've got counsel before you, they're the opponent. They're not counsel to the self-represented individual. But despite that, what would you suggest counsel should be doing or refraining from doing in relation to the accommodation needs that may be apparent for the self-represented person who has a disability? Can I start with Justice Bornstein first?
Well, I mean, just as a matter of decency, I think that you have to figure out a way to delicately deal with it as a matter of practice. I think if you did something like that, it would only enhance your reputation with the court that you're trying to be fair and decent to everybody. But the question is, how do you do that? I mean, it's easy to just say it. I mean, one of the issues is how do you know that the self-represented person does have a disability? They may not wish to disclose it, or they may perceive no benefit to themselves to disclosing of it. So let's assume they don't disclose it and you think you detect it. How do you then communicate it? One of the things that you can do as a court, and so this is not really answering your question about what counsel can do, but as a court, you can convey to the parties that pursuant to the Weiler report that you mentioned earlier, that the obligation is on the court to accommodate people so that they can fully participate in the process. And counsel, where there's one side who's represented, also can ensure that that report is implemented as fully as possible. So it takes the focus away from focusing on an individual who may have a disability and put the focus back on the court to what can we do to ensure everybody's here on a level playing field. So counsel can plug into that, I guess. So that's what I would suggest.
Okay. Justice Malloy?
The first thing counsel should do is raise it with the individual. Now, depending on the nature of the disability, that's sometimes more awkward than others. But, you know, let's take a fairly straightforward case of somebody who has a hearing impairment or a mobility impairment. The person who's self-represented might not know what they're entitled to at the court and what is available. So counsel just simply asking them, you know, advising them of things that are available, what their rights are, and you know, are there accommodations that they might need in the course of this process.
Let me give a practical one that just arises from one of the panels we did in an earlier program. When we did a panel on people with mobility disabilities, one of the panelists emphasized that some of our courts, the accessible bathroom, if there is one, can be quite a ways from the courtroom, and getting there, using the washroom, and getting back at a break may be impossible within the time you're given. If you see a self-represented person with a mobility disability, opposing counsel, the self-represented individual may not know that that's going to be a problem, or that they can speak up about it, but opposing counsel can simply say, I note that Mr. or Ms. So-and-so may need some extra time to go to the washroom, and if so, perhaps the court may want to take a longer break, which is an easy thing you could express without being intrusive, and which would be pretty, helpful.
So if speaking to the person directly doesn't solve the problem or creates a problem sometimes because people take offense, the only other thing I can suggest is speaking to the court staff just to give them a heads up that this might come up, and then raising it at court, depending on the nature of the disability.
David Wright, what about from the point of view of the tribunals that you presided at? Any thoughts? You get a number of self-represented folks at the Human Rights Tribunal.
Yeah, and a lot at the Law Society Tribunal as well. I have two tips for counsel. One is that, and this is true whether the other side is self-represented or not, accommodation isn't always accommodation can be things you do in the moment. And so checking in with people can be very helpful if you're making submissions or cross-examining them. Am I speaking too fast for you? Would it be helpful if I slowed down? Did you understand my question? Do you need me to speak louder? Do you need the court staff to raise the level of the microphones? All of those are little things that you can do in the course, and that we do as decision makers, or we try to do, to check in, particularly where someone is self-represented and may not know about asking in advance. And particularly if you suspect something, those check-ins, without making a big deal about it, I think can be very helpful. And again, enhance your credibility with the court, and enhance the credibility, let's say, of your cross-examination, because you know that you've checked in with the person and they've understood your questions. Okay. The other tip that I have is prepare your clients where there's a self-represented party or a self-represented party with a disability on the other side. That the judge or tribunal member may do some of that checking in, that's a normal part of the process, that it doesn't mean that they're favoring that person, but that the judge or tribunal member or tribunal itself has an obligation to accommodate, and that may be why they're giving a little more attention to the other side, and that's often very helpful. Okay, David Wright, you've worked at 2 tribunals. They don't have a court accessibility coordinator at every tribunal the way we have in our courts. If a lawyer or paralegal is going to go to a tribunal or a court that's not part of the Ontario court system, where do they go for the kinds of things we've been hearing about for 5 different programs here? So it's going to depend on the tribunal, obviously, but all tribunals are conscious of these issues, and typically there is someone or people designated. So the important thing, tribunals vary from tribunals that hear 1 or 2 cases a year to tribunals that hear at the Landlord-Tenant Board, I think about 120,000 cases a year. With the clustering of tribunals that the government is currently doing, that's allowed for more centralization of these kinds of issues. And the best thing is to call the person you're dealing with, make a phone call and say, we require an accommodation. Where do we go? How do we do it? Put it in writing if you need to, and raise the issues as early as possible. Just before I ask my last question, if we could get our presenters from the first panel up here, because we're going to take questions in just a moment. This is the last of our 5 programs, unless we come up with something new after this. You've had 4 years since at least 2 of you were on your first of these. Any closing thoughts you'd recommend to counsel or to paralegal who are watching on what they should do, not do, and what will help them succeed? I'll start with Justice Bornstein.
Well, I mean, you've mentioned it on every one of these panels and at the outset, but really speak to your client, see what you could do to allow your client to feel more comfortable in the court, your witnesses as well, communicate with who you have to communicate with, whether it's the accessibility coordinator or the court staff early. It's simple advice, but it's obviously very helpful.
Justice Malloy.
definitely the biggest issue is to ask in time for something, because as everybody has been saying, there's a real willingness to accommodate every request, but if we don't know ahead of time, it's very difficult. So timeliness is key. And the second is specificity. Exactly what is the nature of the issue that needs to be accommodated. So the more details that can be provided, the better.
Okay, David Wright, tribunal perspective.
I think my perspective is that many of the things that are good practice in terms of asking your client about accommodation because of disability or dealing with an opposing party who may be self-represented in particular or a witness are good practices anyway. That you want to make sure there's understanding. You want to make sure that their needs may be met. And so at the Human Rights Tribunal of Ontario, core values, for example, one of the core values was accessibility. And accessibility was understood, and I think those of us who work in this area understand accessibility. Of course, there's accessibility for persons with disabilities. But more generally, we want our court and tribunal systems to be accessible to everyone. And you talked at the beginning about the importance of universal design. And universal design in our courts and tribunals means not using legal jargon, means speaking slowly, means checking in with people, means treating people as individuals. And those are good practices for everything we do as lawyers and other participants and paralegals and other participants in the justice system.
All right, well, thank you very much. We've now got all our presenters up here. Jill is managing the computer. We're going to just have a couple of minutes for questions. So you have to take all the questions that have come in, summarize them as 2 questions, and tell us what they are.
Okay. We do have a range of questions, and I am almost certain we're not going to get to all of them. So I've got 3.
Go.
One of them was asking for advice about people who have autism, MS, traumatic brain injury, and the lawyer will often use virtual tours, send them information of virtual tours of the courtroom or the tribunal room setup. Wondered if that would be a good strategy for informing people.
As opposed to going there in person.
Yeah,
okay.
And he specifically commented that going in person may be a challenge on time and resources.
All right, let's have the 3 questions and then we're going to answer them all together.
Okay, then there's another kind of bunch of questions that dealt with how easy is it to get accessibility equipment and who pays?
Right.
And the other one is more for somebody with an acquired brain injury or traumatic brain injury. They're dealing with an extremely angry client, difficulty representing him and talking with him about how his anger issues may in fact be contributing to some of his legal issues, and any suggestions on how to communicate with him.
All right,
when anger is an issue.
I'm going to direct these questions. The autism question first I'm going to send to Stephanie if I can.
The virtual tour question?
The virtual tour question.
Ideally, somebody seeing a place in person would obviously be the way to go. If that for time constraints or distance was not possible, then definitely a virtual tour would be ideal. I know in school settings and things, when people are going to new places and airports, people often look at photographs in virtual tours, and that would be exceptionally helpful to give the information, but ideally in person, so somebody could walk around and see the lights, the sounds, those sorts of things would be the ideal situation. But if that was not possible, definitely photos or virtual.
Okay, the question, we need these adaptive equipment, who pays? Laurie McAvoy. Will you pay?
Yes, we pay.
Okay.
So if it's for a court proceeding or court services by the Ministry of the Attorney General, that are offered by the Ministry of the Attorney General, we do provide the accommodation for those services.
By the way, municipal courts may or may not provide comparable services, but you should certainly ask them for them, and if you get any resistance, the argument, if Ontario can do it, the municipality can do it too, is one that you should be considered ready to use.
One, David, just to mention, something that's not in the courthouse, like sometimes there's a joint discovery or that sometimes...
A pretrial proceeding that's not in court may be up to the parties. Okay, final question on traumatic brain injury, anger management issues, suggestions for counsel. Gail, can you help us out with that just in a minute or so?
Sure. Anger management issues aren't uncommon. It depends on what part of the process they're in from the time they've had their brain injury. I would recommend that they have counseling for that, so whether it's psychology, occupational therapy, and social work. There's cognitive behavioral strategies for that. It could also be that it's it could be PTSD. There may be something where this person's isolated or they need to have a more supportive environment. So it might just be that they might just be stuck in the process right now, and just to have that therapeutic support would be helpful.
That's great. Thank you very much. Well, I'm now going to take just a couple of minutes to wrap things up here. This is when we, at the close of this program, should have all the guests from our previous programs come flooding up on the stage. Alas, they're not here. But I want to thank everyone for logging on and watching this. I want to give a huge thank you to the Law Society staff who've done a fabulous job from beginning to end in pulling this all together, and to thank all the speakers here and at the 4 previous programs who, without exception, have been fantastic and have all donated their time generously to help us with this. Let me close with 3 or 4 quick ideas for you. We've been talking about accessibility in court. You should also be thinking about accessibility of your law office. That's required under the Human Rights Code. It's required under the accessibility standards passed under the Accessibility for Ontarians with Disabilities Act. It's an obligation owed to your partners if you're in a private firm, your employees or fellow workers, to your clients, and to your staff. It's also, without exception, providing accessibility for profit-making organizations, adds to profitability. For nonprofit organizations, adds to achieving your goals. It's not just about the building you're in, though that's one thing that matters. It's about your websites. There are international standards on website accessibility, so blind, dyslexic, or otherwise print-challenged people can access them. If your web developer is not assuring you that they know web design for accessibility and are ensuring full compliance with international standards, I encourage you to look for another web developer. When it comes to building design, if you've got an architect who said you've complied with building code, that's not good enough. The building code falls dramatically short for accessibility needs and requirements. You need to make sure you've got people doing your physical design work that meet those the full accessibility needs, especially if you're changing location or renovating. If you've got a step at the front door, there's a fantastic community organization called Stopgap that make low-cost 1 or 2 step ramps, easy to put down, cost not very much, and they'll be very helpful for you when you are schlepping briefcases on wheels, court bags in and out of your office, as well as to your clients who have mobility challenges. There's a wide range of accessibility needs. They're not that hard to meet. Most of them are extremely easy to meet. It's good for your organization, and by the way, it's the law. If you have feedback on this program, please send it to the Law Society. If there's subjects we haven't covered, please tell us, and even though this is over, who knows? We may come up with the sequel or prequel or something. I also want to encourage you, if you have a courthouse in your community that lacks physical accessibility, talk to the Ministry of the Attorney General, get your law association to, talk to your member of the legislature. They are more likely to fix it if you turn up the heat. If you don't ask, they are less likely to fix it because they got lots of other things on their plate. You can make a huge difference. Finally, if you want to learn more about accessibility and the campaign for it in Ontario, go to www.aodaalliance.org. And if you've seen barriers in the court system that you think need to be fixed, let us know at the Courts Accessibility Committee. There are private sector folks, there are government folks, there are judges, and we all need to hear about specific instances to help make for change. Let me know by emailing me at david.lepofsky@gmail.com. And did I mention I'm on Twitter? @DavidLepovsky. Thank you all very much. Wishing everybody a good evening. And if you haven't watched the earlier episodes, I haven't given any spoilers. They're still worth watching. Thank you.